we're going to confiscate your property, which is a violation of the Bill of Rights, but we're going to make it up to you because we're going to compensate you for that property. But if the government passes this amendment that we're talking about today, G4, is it notwithstanding the Bill of Rights? Because is that something that the government's saying, that this will be notwithstanding the Bill of Rights protections for property rights?
Or it becomes law. And then, because it becomes law, that property, which was 5 minutes previous to it becoming law, was able to be lawfully enjoyed in a non-restricted manner, now becomes prohibited. So then they can seize that property. That property is able to be seized then by the government.
The Bill of Rights, the 1960 Bill of Rights, is still a law of this land. I mean, we have a Charter of Rights and Freedoms, which is very important. But the Bill of Rights says very explicitly that Canadians have the right to life, liberty, security of the person, and also the right to enjoyment of property that cannot be deprived except with due process of law. And so if the government, under the Governor and Council, are they bound by the Bill of Rights when they come up with policies to confiscate firearms? Are they bound by the due process of law in the Canadian Bill of Rights when depriving people of the enjoyment of their property?
What I can say is that the Supreme Court ruled in, I think it was 1991 or 1992, in the firearms reference case, that there is no right in Canada to possess firearms.
I don't disagree with you. But in terms of property, if you are given the right to own a firearm as property, firearms are property as well, the government can't just seize that property except through due process of law. Would you say that is correct?
So I think one of the questions is with respect to the federal criminal power, and the reference firearms decision by the Supreme Court of Canada determined that firearms and the regulation of firearms falls within the criminal law power versus the provincial power over property. And it also indicated that there was no right to firearms in Canada.
But this is the Bill of Rights. This is a federal law, not a provincial law. Are you aware of the Bill of Rights? Is it still in force in Canada? Like, it still has power in this country, the Bill of Rights?
Yes. Yes, it does.
And so what I'm getting at here is that it seems like the government, is trying to, through the buyback program in the May 2020 OIC, trying to respect the Bill of Rights and say, we're going to confiscate your property, which is a violation of the Bill of Rights, but we're going to make it up to you because we're going to compensate you for that property. It happens all the time in this country, eminent domain laws, when people have their property seized to build a highway. The government has to compensate you for that. That's the due process of law. But if the government passes this amendment that we're talking about today, G4, and it's not, is it notwithstanding the Bill of Rights? Because is that something that the government's saying, that this will be notwithstanding the Bill of Rights protections for property rights?
So the criminal law falls under the criminal law power that is under the federal jurisdiction. And that's what I can point to when we speak about criminal law and this legislation that is being amended through the bill and the motions. It is under the federal criminal law power.
Yes, I understand that. I guess what I'm trying to say is that because this will be an act of Parliament and not a regulation, as we've already cleared up, this bill will be on an equal playing field with the Bill of Rights, and therefore will not necessarily be subject to the Bill of Rights protections on property right. And so what I'm submitting, that the reason for another additional reason why the government is submitting this through legislation is not only, as they said, to prevent any future government from repealing these OICs, they would have to repeal it through legislation, but they're doing it to relieve the government of any responsibility to compensate people for their firearms. And that's something, that's something that I think is very worrisome.
I want to pick up on a comment that that my colleague Mr. Dane spoke about with respect to the Canadian Bill of Rights in 1960. And Section 1 there says, "It is hereby recognized and declared that in Canada there have existed and shall continue to exist without discrimination by reason of race, national origin, color, religion, or sex, the following human rights and fundamental freedoms, namely, the right of the individual to life, liberty, security of the person, and enjoyment of property, and the right not to be derived thereof except by due process of law. And that's the key. Because as I understand this, as I understand what will happen is the fact that this deceptive Liberal government intends to try to push this through, it means that they don't have to then compensate anyone if they make all these firearms illegal, because that's the due process of law in this country. Would that be a fair assessment? That by listing them as a prohibited firearm, what originally was a non-restricted firearm is now prohibited. That would mean that the government could take that property because that follows the due process of law. Would that be a correct assumption?
So the government can bring before Parliament a bill that can prohibit within the federal sphere of jurisdiction, and compensation is a matter of policy and whether or not to compensate
Right,
owners.
and I appreciate that, but what I guess, let me ask a different way. What I'm trying to ask is, so the government will do this under the guise of public safety. They're going to do this under the guise of due process. They're going to pass legislation. It's going to be forced through without proper debate in the House that should have and could have occurred. They are going to have support, I'm sure, from other opposition parties, and therefore it becomes law. And then, because it becomes law, that property, which was 5 minutes previous to it becoming law, was able to be lawfully enjoyed in a non-restricted manner, now becomes prohibited. So then they can seize that property. That property is able to be seized then by the government because it is no longer lawful, and it is then seizable, if you will, because it was done through due process of law. Would that, am I correct in assuming that?
Due process of law includes the parliamentary process by which Parliament decides what firearms may or may not be prohibited. Whether or not the government chooses or decides to compensate owners in the future.
Yeah, I don't want to get stuck on compensation because that's a red herring, right? Because all I'm trying to get at is that contrary to the Bill of Rights, the way for the government to get around the Bill of Rights is to make what was previously legal to possess, legal to own, was lawfully purchased by millions of Canadians in this country. And many of the firearms listed here, hundreds and hundreds of them are non-restricted. They're using this due process of law to actually prohibit a firearm, and that's how they're getting around the whole process about forcing people to lose their property. Would that be a correct assessment?
So if you're asking what is the impact of the legislation, the impact of the legislation is once it comes into force, these items would be prohibited and would no longer be legal to possess or use.
Okay, that's fair, and I get the coming into force, but my point really is, and I'm going to keep on it for a bit, is that and make the suggestion that the government is using the due process of law to otherwise take and cause Canadians lawfully obtained property to become illegal, and they're using that avenue as a way to circumvent the human rights. Would that the Canadian Bill of Human Rights? Would that be a fair assessment?
So I think as we've already answered, I mean, the Canadian Bill of Rights applies to federal legislation, and once federal legislation has been passed that authorizes or permits that property rights are subsumed by the federal legislation, then following that passage of legislation, which could or would prohibit future firearms, anything that follows that is done as a policy decision made by the government.
I understand.
And I don't think we have, there's nothing else that we can add to your question.
Right, so I won't ask the question, I'll just make the statement. Okay, so the government of Canada has circumvented the Canadian Bill of Rights on property, lawfully obtained property, by making that lawfully obtained property now prohibited and unlawful. That would be the fair way of saying it. So